want to get started, you can introduce yourself.
All right, thank you. My name is Richard Swank. I'm the Associate General Counsel with Florida Realtors. Boy, this has got a lot of feedback. Better? Better? Okay. Associate General Counsel with Florida Realtors. Like I was telling the folks here today, I graduated from Manatee High in 1982. I had lunch at Peaches for the first time in like 35 years. So that was interesting. My sister tells me they just reopened it, so I guess I was pretty lucky. But anyway, yeah, moved here in 1980. Grew up in Northwest Indiana, but moved here in 1980. Basically been here ever since. I went to UF undergrad, Florida State Law, so I've got it kind of covered. I also took a typing class at USF, so I'm kind of got the whole waterfront covered. So today, are we not working now? Yeah, we got a problem. Today, we're going to be talking about generative AI and copyright. And I have kind of subtitled this as, there we go. I've kind of subtitled this as How I Learned to Stop Worrying and Love ChatGPT. All right. I've given this talk several times. Some of you may have seen me give it at midwinter meetings. People enjoyed it so much, I've kind of become the AI guy now. So, but what people really want to know is, all right, what is it? How does it work? And can I use it? Not only can you use it, you will use it. You are using it, even if you don't know it. And I'll be talking about that a little bit. So what is generative AI? Well, generative AI refers to a subset of artificial intelligence techniques and models that are designed to generate new original content, such as images, music, text, or even videos. It involves training machine learning algorithms on large data sets to learn the underlying patterns and structures, enabling them to generate realistic and coherent output that resembles the training data. Generative AI has applications in various fields, including art, entertainment, design, and data synthesis. That's quite the word salad, right? So what does it really mean? All right. First of all, you guys should know that AI is not new. Artificial intelligence is not new. I just quickly looked it up. The movie Metropolis, that was directed by Fritz Lang in Germany, has a artificially intelligent woman in it, all right, and that movie is from 1927, okay? Star Trek has done episodes about artificial intelligence. The original movie Westworld by Michael Crichton was about artificial intelligence, robots, things along those lines. It is not new, okay? But what is new is generative AI, and we'll get to that in just a second. This is a brief history right here. 1956, for the first time, artificial intelligence is used at a conference. It's a computer conference. So that was 1956. They were talking about robots, computers, and things like that long before then, but artificial intelligence, the actual words were coined in 1956. I'm a lawyer, so of course I am familiar with the way in which AI has been used in my field, all right? And throughout the 2000s, just to give you a little bit of an example, I don't know how many people are familiar with Westlaw, right? It's a online computer program that allows you to do legal research, all right? When I went to law school back in the far-flung mists of time, they used to charge something like, I don't know, $10 a minute for Westlaw, all right? Because it was so fast and easy and things along those lines. Had all the books, and you could do all your research with the books, but Westlaw was very, very expensive. When I was in law school, they allowed you to use it for free. So it was like, kind of like a drug dealer, right? Like give the first couple ones for free, make them pay for it later on. Now, of course, you know, anybody can use it. Westlaw, it doesn't cost anywhere near that much. You know, you can also use Bloomberg, you can use LexisNexis, whatever. But the stuff that was, when it became commonly used was the late 90s, early 2000s. All right. But what was used at that point is what is called extractive AI. All right. What that means is you have a database of stuff, big database of stuff, and you're trying to find something in that database of stuff. right? You're trying to find a particular case, you're trying to find a particular statute, you're trying to find a particular, maybe you want to find out if a person has been sued before, if a company's been sued before, something like that. So you use what's called extractive AI. This is what you guys have been using in Google, Alta Vista, Ask Jeeves, whatever you want to call it, going back, Bing, going back, again, 30 years, 20, 30 years, all right? Extractive AI. You say, I want to find this particular thing. And then the artificial intelligence, the AI extracts it, goes over the entire, database that you have chosen for it and finds those particular things, okay? And then gives you your results, okay? But then, now we're getting into the early 2000s, the teens, all right? And a company called OpenAI was founded, okay? And OpenAI decided to create generative AI or use more generative AI techniques. So what is generative AI? Well, we already saw the definition of it, okay? Just to let you know, all of that, I put what is generative AI into ChatGPT and that's what it spit out. I didn't write that. So that's what ChatGPT said, but it's accurate. And it's important that I reviewed that. And that's going to be something we come back to later on. Okay. So 2015, OpenAI is founded. That's the company that did ChatGPT. They also have a artwork company. I don't know if there's this DALL-E or whatever, but anyhow, we'll get to that. All right. So what does generative AI do? All right. What generative AI does is it tries to create, it kind of combines extractive AI with the ability to create something using all the stuff that it's pulling in, all right? The way I try to visualize it, all right? Remember back when you were in school and you had to do term papers. Everybody hates term papers, right? Hated making them, right? Okay, legal briefs are the same way, believe it. So what did you do when you were doing a term paper? All right, well, you were given a topic. Let's say Civil War, okay? That's a pretty broad topic. But anyway, you had to write a paper about the Civil War. So what did you do? You grabbed a bunch of books about the Civil War, okay? Let's pretend for a minute that computers don't exist yet. So you grab a bunch of books about the Civil War, okay? Maybe you narrow your topic. Okay, well, I don't want to do Civil War. I want to do the Battle of Gettysburg, okay, or the Battle of Chancellorsville or something along those lines. So you start narrowing your topic, all right? And then you go to each one of your different books, okay, and you find things to support the thesis that you are writing about. What caused the Battle of Gettysburg? What was the effect of the Battle of Gettysburg, all right? And you may have taken something from this book here, this book here, this book here, this book here, and then you wrote your paper using citations to the various things, various parts of the books that you use, okay? That is essentially what generative AI is, except for reviewing a dozen, 15 books or something like that. It reviews lots and lots and lots and lots and lots and lots of stuff, essentially the entire internet, all right? So GPT-1 was created in 2018. There were 117 million parameters. For the most part, what they did was they took books, they scanned the books, and they just fed the text of the books into the AI programs, okay? Now, another thing that's important to remember, and again, we'll get back to this, AI is what you would call a black box. No one knows how it works except OpenAI, okay? So you don't know exactly how they get to the result that they are getting to.
Governmental?
Oh, heck no.
No?
Oh, no. Oh, yes, it is a private company that is currently worth in the neighborhood of $26 billion. That was founded 8 years ago. So anyway, so 117 million parameters, all right, books essentially used to train. And what they would do is they would essentially ask it to say, give me a paper about the Civil War, but as if Shakespeare had written it. right? So now it goes through the entire internet, or this 117 million parameters that it used, right? Grabbed everything they could find about Gettysburg and the Civil War, and then reviewed every single Shakespeare play and sonnet, and then could write something. It's essentially, it predicts what would happen if you told it to do these things, and the person who did these things had access to all this stuff. 2019, they're up to 1.5 billion parameters. Well, there were more in 2020, but for some reason I got the right thing. GPT-3, again, more parameters. GPT-4, introduced March 14, 2023. All right, now they're up to 1.7 trillion parameters. All right. Another thing you have to remember about AI and the way in which it works, it does things that humans can't do. I mean, plain and simple, there is nobody in this room, nobody who's ever lived, who could review 1.7 trillion parameters and write a book about the Civil War using the language of Shakespeare. You might be able to do it, but you're not going to be able to review that many parameters. Now, this is important, okay? For those of you who have played with ChatGPT or planning on playing with ChatGPT, GPT-4, okay, is the one that basically OpenAI has allowed the public to use. All right, it's no longer proprietary. They've gotten so far beyond it now, I guess they don't care. They're trying to, kind of what I told you about with Westlaw, they're trying to get people hooked on it. So you can go in and ask questions and things along those lines. But very important, the data set was cut off on September 2021. So the 1.7 trillion parameters, but nothing newer than September of 2021. Why is that important? Well, things might have come out since then. All right. Just to give you an example. Pardon? Yes, yes, you can subscribe to these things. ChatGPT and OpenAI are just one of many. There are now, you know, hundreds, if not thousands. Yes, ma'am. It would not surprise me. Just for those of you watching on Zoom, there may be up to 570,000 different AI program things that people can use right now. Okay, now, I don't want to get into a whole thing about this, but how many people are familiar with Senate Bill 264? Yes, okay. Just on a whim, all right, I decided one of the things that Senate Bill 264 says that FREC, Department of Business and Professional Regulation, has to create an affidavit for anybody that's purchasing property in Florida that may be affected by this law, okay? So just for the heck of it, I went in and typed in, please create an affidavit based on Florida Senate Bill 264, and it cautioned me. That came out after September 2021. We can't do that, okay? So it didn't even try it. It apparently looked at a parameter that said when that happened, and said, now from our database, it showed that law was passed after this date. We can't do it. Now, could you pay to go beyond that? Sure, but I wasn't going to. The other thing it introduced was reinforcement learning. You will notice when you are on ChatGPT, sometimes it will ask you, did you answer the question I asked? And they want you to give feedback, okay, to try to improve it, okay? So, again, the predictive tool has made it available to public ChatGPT. However, as we speak right now, all right, OpenAI and all these other companies are contracting with various other companies to integrate this stuff into programs you aren't even thinking about, all right? Microsoft is huge on this. They are reworking Bing, their search engine, to use generative AI. Why? Okay, now you remember, I told you guys, extractive AI, that's a search engine. We look it up, this is what we find. Generative AI, you can just ask Google or ask Bing hey, Bing, blah, 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 blah. And it will essentially converse with you. Okay? It'll sit there and talk to you. All right? I noticed that they are now integrating it. Amazon is integrating it with Alexa. I don't know how many people have Alexa or Siri or any of these other things where you ask something. Now they're going to have it so you don't just ask it questions, where you have conversations with it. Okay, that is generative AI. Okay. Also, they can tailor the parameters to tasks, right? They can limit, they don't, 1.7 trillion parameters is great, but if 1.699 trillion of those parameters don't deal with what you want, it's worthless. Okay. So they are sometimes limiting the database that these things deal with so that it works better for you. For example, they could limit the database to every property sold in Manatee and Sarasota counties since the dawn of time, right? All right. So now we know what generative AI is. We know vaguely how it works, okay? Now we need to find out what you guys came here to learn today. How does copyright affect that, right? Because if something's being created, somebody generally owns it. So if you want to use it, you have to have permission of the person that owns and created it, okay? So how does copyright work? Now, I don't want to step on toes because I know you guys are going to be talking about a lot of this later. But generally speaking, under federal law, a copyright exists when a creative work, that's important, is fixed in a tangible medium of expression. All right, a tangible media expression can include a written page, a photograph, a recorded song, or whatever. As long as it's up here, can't copyright it. The minute you do this or do this, the copyright exists. Now, you can register the copyright with the federal government. That gives you a lot of benefits, okay? But it doesn't have to be registered, okay? The split second it is fixed in a tangible medium of expression, the copyright exists as long as it is a creative work, okay? Now, why am I making the distinction with a creative work? Because some things are deemed by the Copyright Office not to be creative works. For example, I had a case in South Florida several years ago with a company that had created forms. Since the stuff that goes in the forms is creative, is considered to be creative, that could potentially be copyrighted, but the form itself cannot be. All right. So I lost that case, wasn't fun. But anyway, just so you know, it's supposed to be creative. All right. Copyright owners, bundles of rights. This is stuff we talk about in property law, in law school. Bundle of rights, all right? It includes the right to reproduce it, make copies. To publicly display, right? When you go to a bar and you're sitting there having a beer or whatever, and a band comes on and starts playing a Jimmy Buffett song or a Leonard Skinner song or whatever, hopefully, they have gotten the right to play the song. They've paid somebody for the right to pay the song. Publicly display it, all right? Publicly perform, distribute, or prepare derivative works. It's another thing we're going to get into and just say, what is a derivative work? All right, a derivative work essentially takes something that exists in copyright and then make something else out of it, but it's still sort of recognizable as the original thing. All right. A very famous derivative work would be the works of Andy Warhol, right? You've seen his silk screens everywhere. Takes a picture of Madonna or takes a picture of Marilyn Monroe or whatever, makes a silk screen out of it. It's not the original photo, but it is a derivative work, okay? You have to have that right if you want to do that. West Side Story, everybody loves West Side Story, right? You probably know West Side Story is essentially Romeo and Juliet set to music with gangs instead of families in Italy, okay? Now, cool thing about that is Shakespeare's been dead for a very long time and Romeo and Juliet's been in what we call the public domain. We'll get to that in just a second too. So the people that created West Side Story didn't have to have Shakespeare's permission, but if it was still subject to copyright, they would. All right. Real estate context, again, you guys are going to talk about this a lot more later. Unlicensed use of photographs. That's the one that we get the most calls for on the legal hotline. Okay. All right. So now we have to talk about monkey selfies. Okay. It's important. I gave this speech back in January. People said I was nuts. Haha. You're going to find out I was not nuts. Monkey selfies are important. Okay. This is Naruto. Naruto is a macaque monkey. Okay. Now, what happened here is that a wildlife photographer set up, he was observing a troop of these monkeys. And he set up a bunch of cameras where the monkeys lived. Okay. Naruto, who was one of the leaders of the troop or whatever, grabbed one of the cameras, stuck his face in it, and clicked the shutter. Okay. So when I say that's a monkey selfie, I'm not kidding. That is really a monkey selfie. That is a picture of a monkey that was taken by that monkey. So it's a great picture, right? It's a fantastic picture. You got the smile, he looks happy and all that kind of stuff. So the wildlife photographer comes back to the United States, publishes it in National Geographic or whatever. It's a huge success. People are buying prints of it. People are, using it in their educational things, whatever. But they're using the monkey selfie a lot, which raises the ire of, nope, the People for the Ethical Treatment of Animals, PETA. So what does PETA do? They sue the photographer on behalf of Naruto the monkey. Naruto versus Slater, 888 F3rd, 418, Ninth Circuit. Pardon?
Naruto hired them?
No, well, not exactly. They just decided to take it upon themselves to sue on behalf of Naruto. Okay? They were trying to establish that the monkey owned the copyright. Because, remember, go back a little bit, once you have fixed something in a tangible medium of expression, the copyright exists. Naruto did not have to send his picture to the Copyright Office to have it registered. All right? It automatically exists. All right? So PETA figured, we'll get a bunch of money on behalf of Naruto. We'll use it to save monkeys in the jungle or whatever they were going to use the money for. But they said that, Mr. Photographer, you are not allowed, all right, to own this copyright because you didn't take that picture. Naruto did. Okay. Now, the Ninth Circuit held in the case that a monkey does not have standing under the copyright to bring a claim. All right. So Naruto, unfortunately, even though there were human beings acting on Naruto's behalf, they found that Naruto did not have standing, in other words, could not bring that claim. Okay. So the Ninth Circuit essentially dismissed the case, but did not say who owned the copyright. Okay. Everyone kind of assumed that if Naruto took the picture and Naruto doesn't own the copyright because Naruto doesn't have standing to sue, then there is no copyright in the photo. Okay. If no one owns the copyright, it passes into the public domain, something that's been around long enough, okay, or something that's not properly fixed in a tangible medium space, whatever. If the copyright lapses, it goes into what's called the public domain and anyone can use it, which is why I'm very comfortable using that photo. Because Naruto, we know, can't sue me for using it.
Why would you send the device owner?
Because the device owner isn't the person who took the photo. The question is, why couldn't it have been the device owner? Because the device owner wasn't the one that took the photo. All right. It was Naruto. Naruto was the one who exercised the creativity. All right. We're going to get something very close to that in just a second, though. Yes. I don't think so. Yes. So the question is, did the owner of the device have to pay back all that the person that National Geographic, whoever paid him? Absolutely not. Because it's in the public domain. Anyone can use it. Anybody can do anything they want with it. So just like, you know, if the ghost of Shakespeare showed up and asked for the royalties on West Side Story, no, sorry. It's public domain. We made it. That's it. Anything that's in the public domain can be used by anybody. You guys have probably heard Steamboat Willie, the original Walt Disney sound cartoon with Mickey Mouse in it, goes into the public domain on January 1st. Disney has moved heaven and earth to try to push that back as far as they can. They have run out of time. So you are going to see so many ripoffs of Steamboat Willie. Now they're going to start edging into trademark law, which we don't have time for today, but we are going to see so many ripoffs of Steamboat Willie, Mickey Mouse. It's not even going to be funny. Some of you may be aware that the original stories that Winnie the Pooh are based on went into the public domain either last year or the beginning of this year. Okay, there's already a Winnie the Pooh slasher film out. I am not making that up. All right. Now, if that Winnie the Pooh started looking a little bit too much like Disney's Winnie the Pooh, they'd still get sued for trademark infringement. But the actual story, the characters and all that, those are all in the public domain now. Okay. So what does this have to do with real estate? Why do you care? Okay. As we talked about, there are websites proliferating online that allow you to use this generative AI to generate art or text. Okay, ChatGPT, DALL-E 2 is one of the artwork ones, Night Cafe. I think I use Deep AI for these two. Okay, Starry AI Photor. Okay, now, interesting thing about this. Okay, these are not Photoshops. All right, these are something that was actually created by the computer. How, again, we don't know exactly, but okay, these photos never existed. So I asked it to do Darth Vader on a bicycle, and that's what I got. All right, I asked it to create flying fish flying over the Golden Gate Bridge, and that's what I got. Okay, again, like a term paper, grabbed similar images and then kind of mushed them together and created these things. Okay.
Did this come disclaimer with those pictures that you got by then?
We're going to get to that. Yeah. Is there a disclaimer with these pictures? We're going to get to that. Now, again, now we know what generative AI is. We know what it can do. What are its uses in real estate? Florida real estate agents can utilize generative AI in several ways to enhance their business operations. I'm not going to go through all of these in detail. You guys, they have a copy of the slides, or you can contact Florida Realtors and we'll give you a copy of the slides with all this stuff. Okay. Virtual property tours. Generative AI can be employed to create immersive virtual property tours. All right. So you can take pictures of inside and the AI will mush them all together so that it actually becomes like a 3D representation of the inside of the house. Automated listing descriptions. I understand that Stellar is already using these, okay? That basically you put in the stuff and the AI spits it out. Okay, I've got one of these in just a second.
Welcome to video, whatever it is, welcome to, like, oh, they did.
Yeah, they use the AI for it. Right. Right. Engaging and informative property descriptions. All right. Predictive analytics. Right. Generative AI algorithms can analyze vast amounts of historical real estate data, including property prices, market trends, buyer preferences, to generate predictive insights. That sound you heard was the appraisers' blood draining out of their faces. I've done several different I've attended several different AI presentations. Is it going to replace us? Not anytime soon, but there are some professions it's going to hit a lot faster and quicker, right? I mean, if you can program your AI to do an appraisal or, you know, broker's price opinion or whatever, and you can be more accurate than the appraisers, you know, Okay, personalized property recommendations. AI-powered recommendation systems can assist agents in providing personalized property suggestions to clients, right? Things you guys might not even have thought about. Yeah, maybe ask the buyer to say, this is what I want, and spits out a whole bunch of suggestions that you don't know. Market analysis and research, same thing, right? We talked about before about the appraisers. Automated image enhancement. This is big. This is really big. We're going to show that in just a second. Not Photoshop. You don't have to learn how to do all the point and click and cut and paste and all that kind of stuff. The AI does it for you. Okay. Remember that while generative AI can be a valuable tool, it should not replace the expertise and personalized service provided by real estate agents. It is essential to use AI as a supportive tool alongside human judgment and interaction to provide the best experience for clients. Now, remember I showed you that word salad earlier, where I plugged a couple of things into ChatGPT and asked it? Did the same thing here. What's in red is what I asked it. Everything in blue is what it gave me back, including the disclaimer. ChatGPT actually said that. So it's almost like, don't shoot the messenger. You can use me for certain things, but you still have to do some work or a lot of work or whatever. So, but anyhow. All right. Generative AI can be used to create photos or text to market properties. It can generate listing descriptions. It can be used to change the color of paint, the type of the floor, etc. Can add or remove walls, furniture, fences, pools, etc. I understand developers are huge on this. Because basically, they can take the plot of land that they are selling, they can ask what you want on it, right? And the generative AI will build it exactly and give you it may not give you the exact what's going to be there, the exact picture of what's going to be there, but it gives you a really good idea to say, well, maybe I don't want the pool here, maybe I want the pool over there. Okay, or maybe I don't want 2 stories, maybe I only want 1, et cetera, et cetera, et cetera. All of that stuff. Okay, it can create houses or rooms that do not exist. Like I just said, it is distinct from Photoshop because the AI generates or alters the photo or text, right? Again, you don't have to learn all the complicated stuff with Photoshop. This stuff is going to be able to do all of that for you. There's one right there, okay? This, according to Amanda Shendruck, who took the screenshot, this was on Zillow, and it is that description right there. Was generated by AI, ChatGPT. Check out this 4-bed, 3.5-bath home with attached 2-stall garage located in a quiet cul-de-sac just off Edgewood Road. The unique 4-level split layout, et cetera, et cetera, et cetera. Right, the kind of thing you guys have either written or read literally hundreds of thousands of times. Yes.
Like this says family.
Mm-hmm.
So we now have to be careful with that.
Yes, you do.
So just because it's creating doesn't mean.
That is absolutely correct. And I'm going to get to that. Yes. The question was, if there are things in the description that you guys could perceive as problematic, should they be fixed? Absolutely. All right. All right. So just to play around with whatever I was doing before, I told you Darth Vader on a bicycle and Golden Gate Bridge with flying fish. Okay. Tudor house with 2 chimneys. Again, this doesn't exist. This house does not exist anywhere. I did not pull this from anywhere. OpenAI created it. Right. Formal dining room with light blue walls. Same thing. And that one looks a lot better than Darth Vader on a bicycle, doesn't it? That looks pretty good, right? And I did these photos in January. Just imagine how good they look now. Imagine how good they'll look next year. When you have 1.7 trillion parameters to choose from, you can make a pretty good photo. All right. But now that creates a whole new set of questions. We talked about Naruto, a non-human creating something. Who owns the copyright? Who is the creator? All right. Is AI like Naruto the monkey? Does AI have standing in a court? Who can sue? All right. Monkey with a camera, another photo created by AI. That doesn't exist either. That's the same thing. All right. Now, some people who are aware of or understand copyright might ask themselves, what about a work for hire? This is getting closer to what you're already talking about. A work for hire is essentially a copyrighted work created for an employer. They hire you to create it, but because you are working for them, they own the copyright. All right? The employer owns the copyright. Examples: Mickey Mouse, created for the Walt Disney Company by Works and Walt Disney, but they worked for the company. The company owns the copyright. Spider-Man, created by Stan Lee and Steve Ditko for Marvel Comics. I think it was Timely Comics at the time, became Marvel Comics. They created it. Marvel owns the copyright. Barbie, created in the 1950s for the Mattel Corporation, right? Mattel owns the copyright, not the person who created the Barbie. Why do I have a generic picture of a superhero there? Because of copyright. Exactly. I do not have permission to use it. That is just a clip art that was part of the photo or the PowerPoint, which I do have permission to use. So there you go. So, like I said, some people didn't understand copyright, decided, what if we try a work for hire? What if I say the person who created the artificial intelligence, I'm the employer. The artificial intelligence works for me. So anything the artificial intelligence creates is mine, my copyright. So we have the picture, a recent entrance to paradise, right? Completely computer generated. This is, no artist was involved in the creation of this. Yes, sir.
If 1,200 people in the world
Mm-hmm.
go into a chat and enter the same, I recent entrance to paradise.
Right.
What's gonna come up and who's gonna be then the one that is a creator and owner, by the way?
Exactly. Who knows? No one knows yet.
And it's gonna be the same exact.
Not necessarily.
Images that they get?
Not necessarily, no.
Not necessarily.
It could be 1,200 different ones, exactly.
Just like a number, not
Right.
necessarily.
Exactly. So anyway, the person who created the AI program here, who created it, all right, Thaler versus Perlmutter. Perlmutter is the secretary in charge of the US Patent and Trademark Office. All right. Thaler is the guy who created the open AI or the AI system, called it Creativity Machine. Okay. He sought to register the AI artwork created as a work for hire, listing Creativity Machine as the author, the creator, and himself as the owner of the copyright, right? But the Copyright Office denied application on the grounds that there was no human authorship, right? And what did they do? They cited Naruto, the case from Ninth Circuit. So yes, the Ninth Circuit saying that a monkey can't have a copyright is directly analogous, according to this court, to a computer program. Now, when I first started giving this talk, this case hadn't come out yet. Will it go to the Supreme Court? Almost certainly. Okay, and we're going to hear more about this. But as of right now, you cannot register a copyright created by an AI. Okay? Now, the district court conceded that this is all brand new, and that copyright may eventually be granted with some human ownership. So if you give it a certain amount of parameters, like what you're saying, 1,200 different people have 1,200 different things that it tells, but it throws in one, you know, I want the flowers to be purple. I want the flowers to be yellow. I want the whatever's up there. I want the trees to be willows. I want the trees to be oaks or whatever. If you do a sufficient amount of input, the court conceded that there may be something you could copyright in the future, but as of right now, no. And the plaintiff tried to assert all those arguments during the case, and the court was like, should have made them before. Yes, ma'am.
By way of AI, and you edit it, change a few things in what AI came out with? Is that?
That's a very good question. And according to the dicta in the case, possibly, yes. Eventually, we may get to that point. Yes, sir.
Thank you. So when you say work for hire, there's a gap in the supply of information, which we can now pay. So if it's created AI of a subscription that I don't pay for, is that not for hire work?
Well, but you're hiring the company, not the program itself.
Hire the AI say, very.
Right, because again, as of right now, we still need to have human ownership. Now, the input you give to it may eventually push over past that threshold. And you may be able to say, yeah, okay, there was enough put in there. Remember the form thing I told you about? You know, if you put enough stuff with the form, we were told that if we had created a owner's manual that went along with the form, the owner's manual could certainly be copyrighted, but the form itself couldn't. So, yes, sir. Oh, yeah. Oh, yeah. Yeah. Yeah, that gets a little beyond what I'm going to talk about today because it's not really a copyright issue, but beware if you are not already. Next year is a election year. You are going to be bombarded online, especially through things like YouTube, Facebook, Twitter, with people saying things they did not say. It has gotten very, very, very good. Yeah. Yeah. Yes. Yeah. It's gotten super good. Yes, ma'am. Yeah, I'm sorry. Yeah, I'm sorry. The question was, you know, can these be used to mimic people? And the answer is, of course, yes. So, yes, sir. Possibly. Yeah. So again, talking about derivative works, the fact that you added something to this particular work, could you copyright that particular part? Maybe. And again, that's what that's what the district court hinted at, but would not go so far as to say that was true. Okay. Yes, ma'am.
So there's a current class action.
Right. I can answer questions. I just don't know how much, I mean, because I don't know if the Zoom is still running or whatever. Yes, ma'am.
There's a current class action lawsuit against OpenAI.
Spoiler alert. I was about to get there. Yes.
What, is that where you're going?
Yeah, that's where I'm going to go. Yeah, yeah. Because there are some things about these parameters now that are beginning to be teased out by the courts on the sides. Yeah, as a matter of fact, I have one class action lawsuit in the presentation. There was another one filed on Friday. So that's probably even more familiar. The people are more familiar to you guys. So, good. We're right back where we were. Cool. That's good. Okay. Hey, there we go. Okay. Now we're getting to this right now. Okay. Yes, ma'am. Right.
That's obviously put into the generative AI, correct?
Yeah, probably.
Technically, we would own that, right? Correct?
And we're just about to get there. Yeah. Okay. So again, are these websites using copyrighted material? Okay. Again, went back to the same website that I used and I said, give me a steampunk version of the Mona Lisa, or give me a steampunk version of Van Gogh's Starry, Starry Night. And that's what popped up. Okay. Again, not worried because the Mona Lisa and Starry, Starry Night are in the public domain. Yes, ma'am.
Get into the difference between this and intellectual property.
Well, copyright is intellectual property.
Okay, so it's specifically the art end of it. or not?
Yeah, I'm just about to get there. I kind of got to fly through the last 5 minutes here. Exactly, but it would still be, it could be considered a derivative work because I use the Mona Lisa to create it. Okay. All right, so this was the case I told you about. All right, Sarah Silverman. How many people know Sarah Silverman? She's a comedian. She did the voice of Vanellope von Schweetz in Wreck-It Ralph. All right. And authors Christopher Golden and Richard Kadri filed a class action against OpenAI and ChatGPT. Remember when I said back at the very, very beginning, GPT-1, they took a bunch of books and put them together and they used however many, 117 million parameters or whatever, and they started to create their AI engine using that. Okay, exactly what you're talking about. These authors are claiming, okay, that that was an unlicensed use of their copyrights, all right, in order when they created that, okay, because they used their books and they acknowledge they used their books, okay, to create that. All right. Now, there's another case that I can't get into because we just don't have time. Google has been sued for stuff like this before. So a lot of people are not terribly optimistic that this is going to go anywhere, but I'm just letting you know that it happened. Like I said, I put the Sarah Silverman one up there. George R.R. Martin, the guy who wrote Game of Thrones, he and John Grisham, the firm, the Pelican Brief, they joined another class action on Friday. It's doing the same thing. Okay. Uh-oh. We have lost, there we go. Okay, so what can you do now? All right, should you use these services? All right, now this is a little bit outdated based on the entry into paradise case, but review the terms of service of these websites carefully to make sure that you are not granting the sole copyright to the AI website, all right? Make sure that you are not telling them that you need to, that you get the copyright once the courts decide who owns it, all right? Fair use, all right? Concept under copyright law that essentially says you can use copyrighted materials for certain things, satire, political speech, education, that kind of thing. Be careful because it doesn't work that much in a commercial context, okay? You guys, again, are going to hear more about infringement of copyrights of photos and things like that. All right, very important. Code of ethics, right? Article 12, must present a true and accurate picture in your advertising. If you use, we were talking about disclosures earlier, if you use this stuff to alter a photo, even if it's a photo you have complete rights to use, make sure you put a disclosure underneath that it's been altered, okay? Because again, it's going to be so good, people aren't going to be able to tell. So make sure if you've added a pool, or if you've added a fence, or if you've changed the color of the shutters or something, say, you know, photograph altered by artificial intelligence or photograph altered, something. Just disclose the fact that you've changed it. All right, something else to remember. When using text websites like ChatGPT, confidentiality is not guaranteed. Remember, I told you it's a black box. We don't know how it works. We don't know what they do with this stuff. They're using the information to teach their machines, okay, but we don't know what happens to it after that. I don't know if you guys remember, last year there was a bill passed that severely limited the way that personal injury lawsuits and insurance lawsuits could be filed, okay? Some of the larger personal injury firms in the state filed upwards of hundreds of thousands of cases on the last day before that case went in, or before that went into effect, okay? One smaller firm used ChatGPT to draft their pleadings. They don't know, and they gave a lot of confidential information to ChatGPT, social security numbers, addresses, etc. Not good, not good. I've heard the term disbarred thrown around. So conservatively, don't share non-public information. All right. If it's something you would normally put in a listing anyway, number of bedrooms, number of baths, et cetera, et cetera, et cetera, that's fine. Okay. That's why it's so useful for that kind of thing. If it's a picture that you can see from the street, again, not a problem, because that's something anybody can see on Google Earth or whatever. Okay. Now, talked earlier about one of these listing agreements and seeing weird stuff in it. Always, 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 always review the text that AI programs create. All right. There is a phenomenon that's becoming very big called hallucinations. The way it's been explained to me is that AI programs just want to please you. So they will make stuff up, not the stuff you want them to make up, just general stuff. Another example from the law firm filed a brief. Okay. It's like an appellate brief, cited a bunch of cases, did analysis of the cases. Cases didn't exist. Court caught it. Again, sanctioned the attorneys, issued a rule saying that AI could not be used for anything filed in that court. Okay, that'll probably go away. But again, here's another little really quick thing, and I'm just about out of time, but several years ago, a couple of years ago, when Microsoft was beginning to play with this stuff, it created an AI chatbot, just someone you could talk to, right? I can't remember. It was supposed to be a young woman, okay? You would sit there and ask it questions, things like that, okay? So at the beginning, it was very nice. What's your favorite color? Oh, it's green. I like green. And blah, blah. What's your favorite flower? Oh, I like roses, et cetera, et cetera. And it was very, very pleasant. But remember, parameters started to claw around, okay? Within a week, Microsoft had to shut the chatbot down because it was saying some very nasty things. It had found the darker parts of Twitter and Facebook, etc. It was saying very racist things, very insulting things, very sexist things, very nasty. Now, you guys would never do that. I understand that. But again, what we talked about before, fair housing, okay? The chat is going to claw in all this stuff. It doesn't know what's good and what's not. All it knows is that it found 30,000 listings that said this same thing. Okay, so it's going to say, you know, walking distance to the beach, family room, master bedroom, or whatever. If that's something you are not comfortable seeing in a listing, change it, fix it. Okay, just to make sure that because you're responsible for anything you put online. That is it. That is my presentation for today. Do we have any further questions? Yes, sir.
So my fear is more the troll. I fear the attorneys the most, right? This is so unknown. Courts are going to have to, I mean, no one knew what a dozen was until they knew what a dozen was. Do you see any? Have we seen any? Have there been any reports before the legal hotline, or do you want to know that we have this evidence of trolls? Because nobody sued the plaintiff.
Right. Right.
And you get this call, and hey, you know, C did this. We're going to sue you. Like, we're going to sue you for $100,000. Send me 10 grand. We'll go away.
Right.
Number one, that practice should be outlawed, and we should issue permits for hunting. But that's all about.
Right. So,
have you seen it?
okay.
I'm not asking you to predict it.
Right.
Do you
Okay.
see this happening?
So the concern is, will trolls start looking at this stuff, and could they potentially sue based on this stuff? Okay. With respect to the fair housing and things like that, I don't think this is any different from any other listing issue or anything that you guys have. Pretend that the AI is an assistant, and that you would always review what an assistant puts out there, always review the photos and all that kind of stuff, and make sure that that's taken care of. Copyright. All right, copyright trolls. I'm not particularly concerned as long as it is public information. All right. If you started doing things along the lines of, please draft me, who's the guy who does this? I talked about the Civil War earlier. Who's the historian that did all the stuff for the Ken Burns, Shelby Foote? Was that his name? Anyway, you remember the Civil War. If you don't, the whole thing was done. And this is actually kind of funny. And it would, anyway, The whole thing was done primarily through letters from the soldiers home, talking about the battle they had just fought in, the terrible things they were going through, the fact that they couldn't get food or whatever. If someone had done a fictional work of that nature and you decided, oh, I want all my listings to sound like that, all right, do them all like Shelby Foote, I could see that being a problem, right? Shakespeare, no, he's dead. Shelby Foote, very much alive, right? So I could see that being a problem if you did it in some recognizable fashion. Make my listings sound like Harry Potter, right? Okay, I could see that potentially becoming a problem. But as long as they are done the way you guys normally do them, right, to make it sound, make the property sound good. We take a lot of calls about people that do really creative stuff, right? And some of it is just nuts. You guys would get a huge chuckle out of some of it. And I'm sure you've seen some of it, right? Things that aren't necessarily wrong or whatever, but they're just odd, just very, very odd. But they're designed to bring eyeballs, right? Enragement is engagement, I guess. So as long as that continues, right, we're going to probably see people use AI, if they're not creative enough themselves, to, you know, do all my listings like J.K. Rowling wrote in Harry Potter. I could see that being a problem. Will people do it? Sure. But would I do it? Not until things are a little bit better settled about this. I would use them in more generic, I would use it in more generic fashion until we're more settled. Again, this is very, very new. I do have one thing though, it's a good thing I just forgot, I remembered it. I'm sorry, I'm stepping on all your time. I'm gonna get this done really quick. I just got an ad from Getty. You guys remember Getty? You know what Getty is? Getty is a huge like photograph warehouse, and you pay Getty a licensing fee and you can use whatever photo they have. It usually says Getty Images across it or whatever, but you can use whatever photo they have. Getty just introduced an AI tool that essentially uses all of their photos. So if you license their AI tool, all it uses is photos you have permission to use, right? So you can stay out of trouble that way because I can show that I have the license from Getty. Even if Getty doesn't own the actual copyright in what was created, it owns the copyright in the photos that were used to create it. So if we get to the point where one of these class actions comes out the wrong way for the people that created the AI, all right, then you can at least fall back on and say, well, I didn't use something I didn't have a license to make a derivative work of. I used a Getty image that I had license to use. So creative, right? So gonna have to make sure I can answer more of a question. Are we okay? Can I answer one more? Or? No. Okay, one more. That's a good question. Does your errors or omissions cover it? That's a good question. If it covers copyright infringement, probably. But I would check. Okay, that's it.
Okay. We're gonna take a 5-minute break before we start the panel. It's still green. So that's when you're gonna.
Oh, I see. Hello. Is it working?
Oh, okay.
All right, in a minute. Hello, hello.
Yep, it's on.
Hello. Okay. Yep, it's on somehow.
Because I'm not having, yeah.
What do you do with this? Jeez. Hello, hello. Oh. Test, test. Hello, hello. Is it working?
I think you were working.
It is working.
Yeah, you're working.
You're good.
This here is, I didn't know what to do with that. Get this test, test.
If you mind erasing the other two.
I will. I will definitely. Yeah, thank you so much. Okay. Thank you. You have a password? Oh, no, I think just.
Hi. Hi.
Hi, I'm Kit Jadish. I used
I-
to work with you at my.
Yeah, I
I
know.
didn't know if you were.
I do. Yeah.
Oh, you're gonna be on the.
I'm moderating it.
Oh.
No.
Okay,
Mhm.
very nice. It's so nice to see you in
You
person.
too. Yeah. Yeah. I keep up with you on Facebook and your vote and your voting trips and everything. It's good.
Yeah. Very.
Saying what this will be, we could repeat the questions from whoever asks in the room.
Who do you want to repeat the question? Me. Okay. If somebody asks, I know. I know I am. Because I can't take
hear
the
me?
microphone, so
Mary, can you hear me?
just repeat the question.
Very.
Is it working? Is my microphone on? Yeah. Okay.
Can you hear me?
Can
Can you hear me?
Going to
Do you
introduce
mind
me?
if I have you step backwards? I just
No.
want to push this back because it's just for video purposes.
Oh,
The
okay.
Camera's there and we
Oh.
can see Jamie's pretty face where.
No stress. I didn't know. we were going there.
They'll be there.
Okay. Are you going to introduce me or?
Actually, if you want to turn this way, that
Yeah.
would be better.
Are you going to say, introduce me? Yeah. All right. Let's see. Jennifer Thompson. Kristen. Okay. Mm.
Test, 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 test.
Test, test,
Testing.
test, test.
Gotta bring it close.
Be close, yeah.
Yeah, you gotta get close.
Get started with the second part of our copyright and trademark session today. This session is brought to you with, we bring you this session with, an attorney who's going to tell you about copyright, laws. And also we have, somebody here from the MLS, so they volunteer their time to be with us today. And moderating is Deborah Patel-Hogg. She's from Michael Saunders. She's a realtor, a fellow realtor, and she's 40 years now in the industry. So
Yeah, this
so
year.
we're happy to have her and her expertise moderating this. session.
It's still
Thank
pretty
you.
normal,
You're
you know,
welcome.
I think that's quite,
Thank you.
thank you. All right, this should be very interesting because it all pertains to what we do every single day as real estate agents. And we do have Jennifer Thompson Kirsting here and on my left, and she's the Chief Growth and Relationship Officer of Stellar MLS. And then to her left is Adrian Phillips, who is a lawyer at Williams Parker in Sarasota, and she concentrates on corporate law. So I've got the questions here, and so we're going to ask questions, and then if you have a question, raise your hand, and if if nobody can hear you, then I'll repeat the question, okay? First question is for Adrian. Can realtors use others' photos for property listings without breaking copyright rules?
Good question. And like she said, my name's Adrienne Phillips. I'm a corporate attorney at Williams Parker, focusing on intellectual property law. So I don't practice real estate law, but I practice intellectual property law. So that's why it's a good intersection. And thank you for having me here today. Just a quick legal disclaimer, everything I go over today is not meant to be legal advice. I'm just speaking generally to give you some information. So to answer that question, the short answer is no, and the long answer is it depends. Typical lawyer answer, right? So, as Richard explained earlier, to give some background information as to what a copyright is, it's a original form of expression in a tangible form, essentially. So there's lots of different types of copyrights, but typically we think of books, paintings, photographs, that kind of thing. So important thing to understand that Richard touched on briefly is the second a photograph is taken, or a painting is painted, or a sculpture is created, the copyright is created, it's done. And that is without obtaining a federal copyright registration. So if a photographer goes out and takes pictures for a listing, the second they take those photographs, it's copyrighted. And that's important to understand because you don't have to have a federal copyright registration in order to enforce that, although it is helpful and we're seeing more and more photographers do that today. Now I say the long answer is it depends, is because you can use other people's photographs as long as you have permission through an agreement. And we'll talk about that in a little bit.
Questions on that? Yes.
Or what if they have in their agreement with the previous realtor that they're allowed to share?
So we'll talk about the agreements in a little bit, but you essentially want to have an agreement with any photographer's photos you're using. So any past agreements may or may not apply to you specifically.
Okay,
That's another question.
oh, other question? Yes, yes. I didn't hear it very well either.
So I think I heard the question. If you've downloaded a picture from the internet, you right-clicked it, saved it, and used it as your own, can you do that? Is that the question? Adrian, go for it. I know what the MLS would say, but I'll let you say something.
No, you should not use it. Yeah, you should not use it without permission.
That's the same answer the MLS would give you, by the way.
And we'll get into that in a little bit as well, too. Some common mistakes that realtors should avoid, that being one of them.
Okay.
It really
Yeah, repeat the
depends.
Repeat the question.
Oh, yeah, you have to repeat the question.
Yes, if you take a listing and you would like to have amenity photos taken of the pool and the tennis courts, etc., if you pay the photographer for those photographs, can the photographer use them in the future for another realtor or another person?
I think, again, I think it does depend. You have to go back to your license agreement. And what does your license agreement say about the use of those photos? Are they yours to use in perpetuity? Do you have a license that only allows you to use them for that listing? Does the photographer retain rights to use those pictures in future works? So I think it all depends.
I think most of them do retain the rights, because I used to think that the photos were taken of my listing were my photos, and then I found out that they're not, and that you just have the use of them. You pay to have the use of them. That's how I learned that. Any more questions on that? No. Okay. Next question is for Jennifer. Can realtors claim someone else's floor plans as their own when marketing a property?
And we did not tag team this at all, but my short answer is no. And basically, you know, if you didn't create the work, and this is kind of what we lean on at Stellar MLS, is if you didn't create the work and you don't have permission by the owner of the work, such as the architect or anyone else that might have created that, then you don't have the permission to use that in your listings, right? So use that as your guide point. If you didn't create it, then and you didn't pay for or receive a license to use it, it's not yours to use. You know, in all reality, you know, using someone else's floor plans in your own marketing is a no-no. You know, that could be a copyright infringement. Floor plan drawings are typically copyrighted by the architect that's designed that home. So you want to make sure that without that original owner's permission, that you're not using them. To keep yourself out of trouble by keeping that as your North Star. Is if I didn't obtain a license to use it, if I didn't do it myself, maybe I should step back and think about what I'm doing.
Question.
So along those lines, let's shift gears to a builder. Builders produce a lot of materials that are for public, distribution. They give them for us to use, and so forth and so on. I've seen people actually use stuff from like a flyer, they scanned it, and then they use it as an image in the MLS. How about that?
And I think that's going to be a depends answer, honestly, Barry. I think it's going to depend. If that builder has given, it's in that public domain, that's probably okay.
I know they said you could.
Yeah, if
this is taking a piece of literature that they print and hand it out to the office, they just scan it, use it.
Yeah, I would be very leery of that if it were me. And I do have I didn't introduce myself as my background, but I have a background in this industry of almost 38 years. I started off as an agent at the age of 19. I've had my broker's license in 3 different states. I've worked for an MLS vendor, and I've been on the MLS Association side of the business for almost 16 years. So if it were me, I would just be very wary of that.
I have a question for you.
Of course, she has a question for me. Okay.
If, a lot of the builders, especially for condominiums and single family homes, that they have like a page of, features included with these properties, like mahogany doors or just more informational. So if you can't use that without permission, can you rewrite it? And
I mean, I guess a feature sheet is a feature sheet, right? It's features of the property.
yeah,
And I would defer to Adrian on that, but I'm thinking that's a feature sheet. That's features of the property that you could go ahead and say, okay, yeah, I'm going to write that in my remarks. It's got this, it's got that, it's got this.
you could even say the features came from the builder. You could.
Isn't that the same as the Ravite product that it was mentioned earlier?
Don't know.
That derives from?
The derivative work. Derivative work.
Yeah.
Yes.
I would suspect, and I'm not an attorney and I don't play one on TV, but I would say that that's usually my opening remark, but I do have an attorney here with me, so I figured I'd save that one. I think that if you go to, again, that North Star, did I create it? If you created the work, you should be okay. If you paid for the work through a license agreement via a photographer or otherwise, you should be okay. If you've got something in the public domain that you've changed, modified, updated, whatever, added your own piece of information to it, now that becomes derivative works, and that's okay. You just have to, don't just take things for granted that you can use something that you found on the internet.
Also, if you're using things such as a feature of a house, saying this house is blue, that's not copyrightable material. So you wouldn't have to worry about things like that, like for listing details, that those are just facts. So you'd be crossing into maybe uncopyrightable material.
We've got one here.
So
Yeah.
I've had, realtors call me and ask if they can choose a photo that I put into our complex. And I will say to them, sure, they just email me and I'll email back and say, it's fine. Does that cover us? Like, if I ask to use something and the agent says yes, and they email me and say, yes, you can use it, does that cover me?
So,
I mean, how else would you?
that would be a extremely informal agreement. It really depends if any one of you, either side, ever wanted to sue for infringement, how formal that agreement would be held in court. Sorry, I'm gonna walk around my house.
So if the email says I give you permission to use that photo.
So the people.
So we can hear
You permission to use that photo, you're saying it is not necessary, doesn't necessarily cover us.
And I think the other piece to that is, do you have or did you create that original photograph? If you created it and you're giving permission, that's one thing. But again, I would put it a little bit more formally if it were me, just. She's had a question.
Oh, yes,
She's been
yes.
waiting very patiently.
Got the microphone now.
Refresh, please. Sorry.
It won't bite.
Not say a listing, but like advertising on social media. Am I able to use the builder's name, or, because I heard somewhere that you're not allowed to use the builder's name, or is that maybe just certain builders that have that rule, or is that an MLS?
No, in Stellar MLS, you can use a builder's name, but you have to be very careful that you're doing it within the realm of the rules. And I can't recall off the top of my head because it wasn't content for today. And I believe it's that you can't use it in the public remarks. You can put it in the realtor remarks. But let's take a look at the rule and just be sure where that lies, because we also have a field for builder's name if it is new construction. So just make sure we're following the rules, and I'm happy to stay after if you'd like. You're welcome.
Anything that I create or am given permission to use or reproduce, should I watermark it before I upload it anywhere? I mean, with AI today, anybody can remove watermarks, but would that be a layer of protection?
That would more so be a personal decision of yours, if you were concerned maybe about people stealing what you create. Make that's a personal decision, really up to you.
Okay. Is there anyone else that had?
Any online?
Oh, is there any Zoom? Yeah.
No? Okay.
Okay. This is for Adrian. What could be considered a trademark infringement?
Right, so it's important to understand copyrights and trademarks are two different things, and a lot of times they often get confused. Whereas a copyright, we're thinking of a work of art, where a trademark can be all sorts of things. It can be phrases, words, very popular logos, combinations of words. That the point of it is if I'm a consumer and I see that trademark there, I automatically think of that business. So where you get into trouble with trademarks is if two marks are extremely similar and a consumer gets confused, that's when a trademark infringement can ensue. So a popular logo that people think of when they see the golden arches is McDonald's. So McDonald's Corporation has trademarked the golden arches. So a customer is able to understand what the golden arches mean and who it's associated with. A big example in the real estate world is a lot of builders now, in addition to trademarking their name, they're also trademarking neighborhoods. Names of neighborhoods are being trademarked as well. And any sort of logo, any sort of combination of phrases, if they have a tagline, those are being trademarked as well too. So as real estate agents, that's something to keep in mind as well. question for Adrian, I believe. Is there a statute of limitations on this? Trademarks, they last forever. Okay, what about copyrights? Copyrights do, I believe they last 70 years after the death of the one who created it.
Oh,
So as long as a trademark is being renewed by an attorney, a lot of trademarks get abandoned. They can last forever.
Can someone else claim the trademark, like a family member?
I mean, there's trademark disputes all the time where that kind of thing happens, yeah. Where people will register a trademark and then it pops up and someone says, oh, I had that idea 40 years ago and I've been using it since. That's where a lot of lawsuits come about.
okay. Questions? No. Okay, this is also for Adrian. What should realtors keep in mind about intellectual property in real estate transactions?
Right, so of course, we've already said this, but it bears repeating. Generally speaking, in a real estate transaction, you just want to be careful, right? So if you think that you might not have permission to use something, or you think it's risky, probably best not to use it. Just want to be careful in the entire real estate transaction for copyrights, trademarks, all that stuff. Of course, the hot ticket thing right now is photographs. So if you think that you might not have permission to use a photograph, or you think, oh, it's no big deal, it's a blurry photo, I'm not worried about it, you should just be very careful. And that's the same thing with floor plans too. If you think you might not have permission to use the floor plans in your marketing materials, and you can't point to an agreement in place that you have with someone to use those, you don't want to use it. Another important thing in your real estate transaction to keep in mind is you constantly want to be auditing your website or your social media feed. It's really important. Maybe you weren't thinking one day, posted a photo, weeks go by. It's important to check those things. Go back, and if you did use something you shouldn't have, take it down.
Okay, I have a question about that. If you have permission, if you call a photographer and say, I'm listing this property, it was listed before with someone else, you took the photographs, may I purchase them or whatever, the rights to use them. Do you need to get permission too from the previous listing agent?
So that's something important, and it's a common mistake that is made, is before you're using these photographs, you want to do your background research and determine who actually owns these photographs.
Okay.
So is it the individual photographer? Is it the monkey? Is it the employer of the photographer? Who owns that? And you kind of got to go back and determine who that owner is and make sure that permission is in place.
Okay, question.
Condo association. Condo association posts photographs and also floor plans. So are those all right for us to use?
I would ask them. I would ask the association, is it permissible? If they're on their website, I would guess, I don't know, but I would always ask. Yeah, I would ask. Don't assume. I missed, I think we missed the first part of the question. We
Yeah, it's
can't hear
hard
it
to
up here.
hear you.
Media information, okay? And they provide us with several different pieces of social media, so finding house, report.
Okay.
Things, so on and so forth. Am I to assume that I am authorized to use that? And I know it happens when you assume something, but do I need to go to my broker and say, you've sent this out into my email for social media?
Can I use that? Do I need to separate?
Like Agent icon, I think is what you're
Agent
talking
icon.
about.
And typically when you're purchasing and Adrian, please step over me if I say something wrong or kick me or something, I'm not sure. But if you're purchasing a software, if you've got a software product that's producing this stuff for you, that's part of the license agreement in the software agreement that you have with them. So I would go back. I mean, I'm guilty as charged. How many of us read terms of use when we sign up for a software product, right? Adrian's going to kick me now for not doing that, but you know, you have to read that stuff. And typically that's where you're going to find those license uses, the authorized uses. Where can I use it? How can I use it? What do I need to do? And how do I go about getting additional uses that may not be predetermined in that agreement? So, I mean, it's probably okay, but again, I would err on the side of caution and, you know, maybe go back and read the terms of use or the end user license agreement that you have for that product.
Yeah, and photographers, when they're suing, people for using their photographs, they could go after your broker for using it, they have permission, and then also you individually as well, so.
Okay, no more questions on that? Okay, some of these overlap a little bit.
They do.
Let's see. Yeah, Adrian, what common mistakes should realtors avoid when using images in property listings? Let's talk about it.
So, a lot of common mistakes, some we already discussed. But I want to touch a little bit on the photographers. So photographers are no longer hesitant to take people to court. If they have their copyright registration, they have something easily to point to and they can take you to federal court. But what has developed in the past year is now in Washington DC, there's a copyright claims board, which is kind of like a mini separate court system, but it's only for copyrights. You don't need an attorney to file a claim there, and you can receive damages up to $30,000. So if we're talking about a small mom and pop photography studio, this is a really good option for them. And we're seeing, it's only been around for a few months, the Copyright Claims Board, but what we're seeing, about 80% of all the claims are from photographers, a lot in real estate, saying, hey, they're using my photos, I'm suing them. So common mistake is maybe not taking this seriously, not thinking the photographer is going to do anything about it, because the government has ensured now, in additional to the federal court system, that they have their own separate copyright claims board that they can now bring a lawsuit under. Another common mistake is taking a photo from Google. So let's say you're selling a beachfront condo. You want to put a picture of the beach in your listing. Of course, the beach is beautiful. Everyone wants to see that. It's going to help you sell the condo. You're going to go out that morning. It's raining. Okay, it's not the best photo. So you're in a jam. You go to Google, you search beachfront condos or beachfront beautiful sunsets. You pull that photograph down, put it in your listing and say, okay, it's fine. There are now law firms around the country, personal injury firms, that will go through and scrub all these real estate listings, people's blogs, people's social media, and they contact the photographers and say, hey, you have a case here. We'll send a cease and desist letter on your behalf. We'll ask them for $5,000. And it works. These cases settle.
Yep.
So a common mistake there is, you know, if you're in a pinch, you're in a bind, don't just grab that photo from Google. There are a lot of bad actors out there that are willing to assist these photographers who worked hard on their photographs, who want that recognition. Of course, the photographer is not going to turn them away. They would be happy to welcome that law firm in there.
And can I just piggyback on that? There are places that you can go and purchase those photos and purchase the license to use those photos.
There's some websites.
Yeah, I mean, there's places that you can actually go and obtain photographs and have the authorized use to use them. That's my point I was trying to make. Well, there's Canva, there's Shutterstock, there's tons of places. Right. Goes back to licensing. The works. Yep.
another common mistake too is, I think this was touched upon earlier, is you get permission from a photographer and then you're not putting it in writing in a license agreement. Maybe you have a verbal handshake, maybe you've been friends with that person for 30 years, you're not worried about it, but not putting it in a formal, in writing license agreement is a big mistake. Because yes, you've been friends with them for a long, long time, but who's to say 10 years from now, you get in a fight, they sue you for infringement? Not how long ago. What's that?
What is enough? Just email?
So the more formal agreement, the better. So it really depends. If that photographer decides to sue you, it would be up to the court to determine if that agreement would be valid.
You want to be specific. Be specific. Specificity rules. Right. I think there was a question in the back. Hang on, she's bringing you the mic.
Again, it depends. It depends how formal you want to make it. Some license agreements can be 5 to 10 pages because they are very specific and they say the length you can use the photos, what territory you can use the photos, how much you're going to pay me, versus others can be one pager saying, hey, you can use my photos, have a good day. That's be a personal decision and be a personal decision of the photographer as well.
I know in some cases you can purchase photographs, but it's really very expensive, so that nobody else can use it. But it is
Yes.
really expensive.
Exclusive use translates to more money.
Jennifer, how can realtors prevent plagiarism in public or realtor or not?
Oh, what do you think I'm gonna say? Write your own. No, seriously. If you're using Chat GPT by AI Pro or the others that are out there, like Google has Bard or any other platform to help write your remarks, just make sure that first of all, read them. Please read them. Don't just copy and paste because you want to fact check what it has written, right? You want to make sure that it's in your own words, so to speak. It's how you would speak, right? Some other things to think about when you're thinking about plagiarism is number one, let's understand what it is, right? It's the act of copying someone else's work and passing it off as your own, right? That's the definition of plagiarism. So don't just copy somebody else's comments, descriptions, etc., and plug them into your listing. That creative work, that description that was written by that original agent is a creative work. It is copyrightable. So don't just copy and paste. Make sure you're citing sources. If you're doing something of that nature, if you're creating this presentation or a dissertation or whatever it happens to be, citing your sources, paraphrasing. You might see something that looks wonderful and it's got a great description of a piece of property or a neighborhood. Take it and turn it into your own words. Now you're not plagiarizing, right? You got the idea. It might have gotten your juices flowing and you got an idea going. There are some tools out there you can use to make sure that you're not, that what you have written has not already been exactly written, but 9 times out of 10, if you wrote it, it will be okay. And then again, write in your own voice. You've heard me say this already, create it yourself, write in your own voice, be specific. I said that before too. And use original content whenever possible. Make sure you're just using your own content, creating your own works, and it's yours and it's in your voice and people know you. I mean, people know how you talk. They know how you speak. People know how I speak. And it's okay. She hasn't kicked me yet, so it's good. But again, just don't copy and paste the remarks from one listing to another unless it was your listing, and then it's okay because it's your work, right?
And Jennifer, isn't there a list somewhere in Stellar MLS that gives you the verbiage, the words that you can no longer use? Like you
No.
can't say master bedroom.
No, there's no specific list. I will tell you that our system on the, when you're writing your remarks, there's words that will come up in red, right? There's caution words and there's stop words. Caution words will stop you and say, hey, are you using that word in the right context to avoid fair housing issues, right? White cabinets, right? White cabinets is going to be a caution because you've used the word white, but in the context of what you're saying, it's okay. Right? So you just want to be careful. And I know people get frustrated. I've got an agent, his last name is White. Poor guy. Realtor remarks, last name is White. He says, can you not help me out here? And I'm like, you could change your last name, but I can't because that's just cautionary and stop words. So there are federal fair housing words that are, and there's really no official list, unfortunately.
Cannot use manned guard gate, you cannot use master bedroom. And
Oh, she can't hear. All right, use this one.
I've blown them both up. I don't know why. Hello? Oh, yeah. Yes, you can't use a manned guard gate. You can't use master bedroom. You have to say main bedroom. And I believe you can't say walk to shops and restaurants.
And at Stellar, we are changing the label from master bedroom to primary bedroom, finally. So, oh, primary. Because owner could be, you just don't know. Walk, not everybody can walk. Walk to the beach, walk to shops, not everybody has the ability to walk. Can't walk. I know.
All right. Okay. This is for Jennifer. What's the significance of registering agent and broker website under the DMCA, especially for copyrighted photos and floor plans on IDXT?
Okay, Adrian, you can't answer this, but how many people know what the DMCA is? I know you do. So that's the Digital Millennium Copyright Act. Okay, and what that is that's to allow website provides legal protections and benefits for copyrighted content like photos and floor plans that are displayed on IDX or Internet Data Exchange feeds on websites. Okay, so under the DMCA, and I'm going to read this because I don't want to mess this up. A website owner can designate a registered agent who will receive notifications of alleged copyright infringements when someone believes that their copyrighted content is being used without permission on a website. So that person, that photographers, they see a website, they see a picture on your website, and they say, that's my picture, and that agent doesn't have the license to use that picture. And you're like, whoa, not my listing, not my problem. Well, it is. So it is your problem, but by having a registered agent for the DMC takedown notice, you have that registered agent, that takedown notice, they contact that takedown email address and they request the photo to be removed. So if it's your website, it's not your listing, that takedown notice comes to you through your inbox and you're like, not my listing, don't ignore it, send it to Stellar and we'll contact the listing owner and say, your photo is in violation of a copyright and we'll take it down. Okay. But you have to be aware of these things, guys. Ignorance is not bliss in this case. This is real stuff. People have been paying settlements out in lots. So by complying with the DMC takedown, you are now avoiding potential legal liability. So you want to avoid that. Stellar does have a DMCA toolkit available on our website for you. We've had it up there for years, and I'm happy to see everybody writing this down. So go to stellarmls.com, search for in the little search guy up in the top right-hand corner. Use a little magnifying to search for DMCA. That's all you have to do. And there's two things that'll pop up. One is actually the takedown notice that you can use. And then the other is a whole PDF on a toolkit for DMCA compliance. And we're here to help, guys. Seriously, if you have a question, we're here to help you with it. Don't hesitate. We'd rather take the phone call than have you put yourself in a precarious position. Question in the back. You cursed me. You cursed me. You'd have to, I'd have to go back and look at the rules. There is a place you can do it. I don't believe you can put it into the public remarks. If I'm not mistaken, it has to go into the private remarks. But I also recall that we had a field for builder's name that you can put the builder's name in the field in the listing data entry. Yes, there's a model number. Yep, there's a model field as well. Well, Stellar MLS doesn't, we don't control what you do in social media. Thank God. They may. Right. That's very, very possible. Builders can do any, I don't know. Can't answer that question, but field in the listing entry where you can type in the builder name and the model number or the plan number, whatever it is, it's in Stellar on the listing entry. Well, no, you could do it on brand new construction. If it's a resale, you can still, correct. And you can always reference it in the realtor remarks for sure. Because that's realtor to realtor.
Any more questions? I think we're done with these questions.
How about, you want me to repeat it? I'm loud, right? So the question was, I'm using social media. This is outside the MLS. I'm just using social media. I'm posting Happy Memorial Day, et cetera, et cetera. I'm using pictures that I saw in somebody else's feed with the flag and the this and the that. What are the legal implications of that? And how do I go about mitigating that? Is that a fair? Maybe I put a song to it. I like that. Hope you own the music. No, just kidding.
So that's, another personal decision and a risk assessment. So if you're going on Google and you're pulling down a very generic flag for Memorial Day that hundreds of thousands of people have posted, you're posting on your Facebook, you're not making money off that, maybe not so risky. But maybe a photographer took a picture of that flag, they're scrubbing the internet, they see it on your Facebook, they'll send you a cease and desist letter to take it down. There may not be any money behind it, but you could still get a cease and desist letter and nobody wants to deal with that. Right, so a business page, you might be making money from that, but a personal page, you're probably not gonna make money for that. And usually the photographer could very much still sue you, but there wouldn't really be any damages with that. Yeah, it really depends, yeah.
Depends on the license agreement.
It's definitely, I'm an attorney, so I'm really risk averse. So I would never do something like that because I would be very scared, but it happens all the time. So it's a risk assessment, it's a personal decision, of course.
In the back.
Yes.
Right.
Yeah, music's a bit more complicated, a little outside the scope, but you're right. That's just, your picture will be fine without some music. What do you mean? So, no. So if you have the realtor's permission, who said, hey, can you please share this, help me out? Did that original realtor get permission then for the photographs? So if I am one of those personal injury law firms, I'm gonna look at everyone who's using that photo and come after everyone in individual claims. So, if you wanna do that, I understand networking is very important and sharing things in this market. I would ask your original real estate friend, do you have permission to use this? Maybe can I see the license agreement? That type of thing. Okay. That's it. I think we're going to have any Zoom home. Thank you.
Thanks, everyone.